My daughter-in-law demanded I leave my estate to her 6 stepchildren. When I refused, she sued me and faced a brutal reality check. I, 58M, am currently dealing with an unprecedented situation that has torn my family apart. My second wife, 47F, passed away 6 months ago after a brief battle with aggressive cancer, leaving me to manage our blended family. I have 2 biological children from my first marriage, my son, 32M, and daughter, 29F. My late wife had no biological children, but was close to her sister's 3 kids. The current drama centers around my son's wife, 30F, who he married 2 years ago. She's a widow with 4 children from her previous marriage, ranging from 6 to 12 years old. When she married my son, I welcomed them all into our family, though I noticed some concerning behavior from the beginning. Some background. I built my wealth through 35 years in commercial real estate development. Started from scratch, worked long hours, and made calculated investments. My first wife and I divorced amicably when our kids were teenagers. She remarried and is doing well. My late second wife was an incredible partner who supported my business growth, and we had a clear prenuptial agreement about keeping our finances separate. My son works in pharmaceutical sales and does well for himself, but his wife hasn't worked since they married. She's been increasingly pushy about financial matters, constantly bringing up college funds for her kids and hinting about inheritance. I initially attributed this to maternal concern, but things escalated recently. 3 weeks ago, I met with my estate attorney to update my will. I'm leaving the majority of my assets, approximately $8.5 million, to my biological children, with specific provisions for my late wife's nieces and nephews as per our prenuptial agreement's terms. I also set up education trust funds, $50,000 each, for my son's stepchildren, which would be managed by a professional trustee until they reach college age. When my DIL learned about these arrangements through my son, she became furious. She arrived at my house unannounced, demanding that I split everything equally between all 6 grandchildren, her 4 plus my daughter's 2, effectively reducing my own children's inheritance. She claimed that as my son's wife, she had a legal right to ensure all the children received equal treatment. I explained calmly that while I care for her children, my primary obligation is to my biological family and honoring the agreements made with my late wife regarding her nieces and nephews. She then made a shocking threat. Either I change my will, or she'd ensure my son never saw his biological child that she's currently expecting. That's when I realized this situation was more calculated than I'd initially thought. My son had mentioned they were trying for a baby, but the pregnancy announcement was strategically timed right after she learned about the will. She'd been laying groundwork for months, making comments about family unity and dropping hints about estate planning. The next day, my son called sounding distressed. He attempted to convince me to compromise by giving his stepchildren equal shares, saying his wife was just being protective of their future. I maintained my position, explaining that the education trusts were already a generous provision, and my decision was final. That's when things escalated dramatically. My DIL consulted with a probate attorney, claiming she could contest my will on behalf of her children due to their status as my son's stepchildren. She's arguing that by providing for my late wife's nieces and nephews, but not giving equal shares to her children, I'm showing discriminatory intent. To make matters worse, she's begun a smear campaign within our extended family. She's telling everyone I'm discriminating against her children while favoring others. Some relatives have taken her side, suggesting I should embrace modern family dynamics. My daughter is outraged about the entire situation. She says her brother is being manipulated and needs to stand up to his wife. My first wife, who typically stays neutral in family matters, called to express concern about our son's marriage and believes he's being coerced. The situation took an unsettling turn when my DIL started using the children as leverage. She began restricting my access to my son's stepchildren, claiming they were distressed after learning about the inheritance arrangements. This was particularly difficult because I'd developed genuine relationships with these kids over the past 2 years, regularly spending time with them during family gatherings. My son appeared conflicted, but increasingly sided with his wife. He revealed that she'd threatened to move back to her hometown with the children if he didn't support her demands. I could see his struggle. He'd bonded with his stepchildren and was excited about their baby, but he recognized his wife's behavior was becoming increasingly extreme. Then my DIL escalated matters further. During a recent family dinner at my house, She excused herself to use the restroom, but instead went to my home office. My security system, installed after several valuable items went missing during previous family gatherings, recorded her attempting to access my filing cabinets, presumably searching for financial documents. What she didn't know was that I keep all important documents in a bank safety deposit box, with only copies at home. These copies, which my son had access to for emergency planning, contained outdated information anyway. She tried using these documents to argue that since my business grew substantially during my second marriage, my late wife's family had no claim to any inheritance despite our prenuptial agreement. My estate attorney assured me her claims were baseless, particularly given the clear terms of my prenuptial agreement with my late wife. However, he advised documenting all interactions and potential legal violations to protect myself and my estate. This foresight proved invaluable. A disturbing revelation came through my daughter, who works as a compliance officer at a regional bank. She discovered that my DIL had attempted to open trust accounts for her children using falsified documents that made it appear I had already legally committed to leaving them equal shares of my estate. The bank's fraud detection system flagged these attempts, triggering an internal investigation. My first wife then shared something concerning. My DIL had approached her 6 weeks ago, proposing they work together to challenge my will. She offered my ex-wife a percentage of any successful settlement in exchange for supporting her claims. My ex-wife declined and documented the conversation, worried about our son's situation. The situation culminated during a family dinner at my daughter's house. My DIL, apparently frustrated by her failed attempts, started making accusations about my business practices. She claimed she had evidence of tax irregularities and threatened to report me to the IRS unless I agreed to her demands. She even recorded this conversation, seemingly trying to catch me saying something incriminating. This was the breaking point for my son. He discovered that she'd been secretly recording family conversations for weeks without consent, illegal in our state. He also found emails revealing she'd consulted with multiple probate attorneys, looking for someone willing to take her case on contingency. Most significantly, my son uncovered information about her past. His wife's first husband had passed away 4 years ago, and she'd attempted similar tactics with his family. She had tried to claim a larger portion of her late husband's family trust by threatening to restrict access to the grandchildren. The family had settled privately to maintain relationships with the kids, but they documented everything with their attorneys. After consulting with my legal team, I decided to take decisive action. The evidence we had gathered, including the security footage, fraudulent bank documents, and illegal recordings, gave us a strong position to protect both my estate and my family. First, we filed for a temporary restraining order based on harassment and attempted theft. The evidence was compelling. Security footage of her attempting to access my office, documented threats, and witness statements from family members about her escalating behavior. The court granted the order, legally preventing her from coming to my home or workplace. My legal team then sent a comprehensive cease and desist letter addressing her defamation and fraudulent activities. We included evidence of her attempted bank fraud, the illegal recordings, and her documented attempts to extort changes to my will. Her attorney withdrew from representing her within 48 hours of receiving our documentation. The situation shifted dramatically when my son made a discovery in their home office. He found a detailed journal outlining her plans, dating back to before their marriage. It included research on my assets, strategies for manipulating family relationships, and notably, a timeline that showed she'd known about her pregnancy weeks before the inheritance discussion, but had deliberately withheld the announcement. Through his own investigation, my son located and contacted her late husband's family attorney. The attorney, now freed from client confidentiality due to documented fraud, confirmed her pattern of behavior. She had extracted a significant settlement from her first husband's family trust by threatening to relocate with the children. They provided sworn affidavits detailing her past actions. My son filed for divorce and temporary custody orders. Given the evidence of her attempts to use the pregnancy as leverage, his attorney also filed for an emergency hearing regarding the unborn child. The court took the matter seriously, particularly given the documented pattern of using children for financial gain. Her response was predictable. She threatened to move back to her hometown with her children and deny my son access to their unborn child. However, we had anticipated this. Her threats, combined with the evidence of similar past behavior, allowed my son's attorney to secure emergency orders preventing any relocation during the divorce proceedings. The court ordered a guardian ad litem to represent the interests of all children involved, including the unborn child. They also mandated a forensic psychological evaluation and appointed a custody evaluator to assess the situation. These independent experts would prove crucial in the proceedings. Meanwhile, the bank's investigation into her fraudulent activities had escalated. As a financial institution, they were legally obligated to report suspected fraud to the authorities. The evidence was substantial: forged documents, unauthorized use of my personal information, and attempted identity theft to create false trust accounts. My DL support system began crumbling. Family members who initially sided with her withdrew their support after learning about her recorded threats and fraudulent activities. Her own parents, after being presented with the evidence, admitted to witnessing similar behavior in her previous marriage, but had hoped she would change. The criminal investigation expanded when investigators discovered a pattern. She had attempted similar schemes in 2 other jurisdictions, using her children as leverage to extract financial settlements from wealthy family members. These cases had been settled privately, but the documentation existed and was now admissible as evidence of a pattern of behavior. The divorce proceedings revealed even more troubling information. Their marriage counselor, subpoenaed by my son's attorney, provided session notes documenting her admissions about using pregnancy and children as bargaining tools. While counseling records are typically confidential, the court allowed this evidence due to the documented pattern of fraud and manipulation. The legal consequences unfolded systematically. The district attorney's office charged my DIL with multiple felony counts: attempted grand theft, forgery, identity theft, and criminal fraud. Her previous settlements were examined as part of establishing a pattern of behavior, though they couldn't be reopened due to statute of limitations. The family court expedited the divorce proceedings due to the pending criminal charges and my DL's pregnancy. Based on the forensic psychological evaluation and the custody evaluator's recommendations, the court granted my son temporary legal custody of their unborn child, with supervised visitation for my DIL once the baby was born. This decision was heavily influenced by the documented evidence of her using children as leverage in financial disputes. Regarding her 4 children from her previous marriage, the court couldn't grant my son any legal rights as they weren't his biological or adopted children. However, given the established relationships, the guardian ad litem recommended, and the court ordered a transitional visitation schedule, allowing my son to maintain contact with his former stepchildren if they wished to do so. This arrangement was contingent on their mother's agreement and the children's desires. The criminal cases concluded with a plea agreement 3 months later. My DIL pleaded guilty to 2 felony counts of attempted fraud and 1 count of identity theft. She received a sentence of 18 months, with all but 90 days suspended, followed by 5 years of supervised probation. The conditions included mandatory psychiatric treatment, financial monitoring, and restrictions on opening new accounts or acting as a fiduciary for others. My grandson was born during this period, a healthy boy. The custody arrangement established by the court ensured my son's parental rights were protected. The final custody order granted him primary physical and legal custody, with my DIL receiving supervised visitation twice weekly at a court-approved facility, contingent on her compliance with probation terms and mental health treatment. My son maintained contact with his former stepchildren through their maternal grandparents, who had temporary guardianship while their daughter served her jail time. The grandparents, seeing the positive influence my son had been in their grandchildren's lives, facilitated these visits when the children expressed interest. The estate planning remained as originally structured, though we added additional legal safeguards. The education trusts for my son's former stepchildren stayed in place, but were modified to be managed by a corporate trustee with strict disbursement conditions directly to educational institutions. This ensured the funds would be used as intended while preventing any manipulation. My DIL's actions had far-reaching consequences. The publicity from the criminal case led to her losing her notary license and being barred from working in any fiduciary capacity. Her probation terms explicitly prohibited her from engaging in any legal actions against family members without court approval, effectively preventing future attempts at estate claims. The extended family eventually reconciled, though relationships changed. Those who had initially supported my DL's claims apologized after seeing the evidence presented in court. My son and daughter grew closer through this ordeal, with my daughter helping her brother navigate single parenthood and the legal aftermath. My first wife proved to be an unexpected ally, providing crucial testimony in both the criminal and custody cases. Her documentation of my DIL's attempted manipulation of the inheritance situation helped establish the pattern of behavior that influenced both the criminal sentence and custody decisions. Today, 6 months after the final court decisions, things have stabilized. My son is focused on raising his son and building a career, while maintaining whatever relationship is possible with his former stepchildren. My DIL's parents continue to act as intermediaries when necessary, prioritizing their grandchildren's well-being over past conflicts. Looking back, standing firm against the manipulation was crucial. It not only protected my family's financial future, but also exposed a pattern of exploitation that had victimized other families. The legal system worked as intended, using evidence and due process to reach appropriate resolutions. The irony remains that in attempting to force her way into my will, my DIL lost far more than any inheritance would have provided. Her freedom, her reputation, and most importantly, her ability to use her children as bargaining chips in future schemes. Her actions ultimately cost her the very things she claimed to be fighting for: family stability and her children's